A very good evening to one and all. This is a very tough time now because after we have a good motivation session, really now everyone is a fresh mind. Even if it is a technical session, it's okay, but even not even, this is a legal plus technical, both combination like FDC product. So, and I'm also like, regular sincere work enforcement officer. I'm not very professional presentation of any lecturing type. Kindly bear with me. Yeah. So this will be now, I would like to know, firstly, I would like to thanks for invitation given by this Drugs Control Officers Welfare Association President and other office bearers. Secondly, I would like to extend my sincere thanks to my drug controller, Dr. S. Umesh. And also I recognize my most senior officers and senior officers present here. And also my mentors, Dr. Jagshetty sir and other senior officers here. Finally, this today topic is search and seizure provisions for drugs under new criminal laws. This is more than a presentation. I can say, let's we understand what is the new provisions given under these new criminal laws enacted in the 2023 effective. Let's we start this. The new criminal laws has been passed in the parliament in the year 2023 to, this is very difficult thing, passed in new criminal laws to replace the overall existing new criminal justice system in India, that is Bharatiya Nyaya Sanhita 2023, Bharatiya Nagarika Suraksha Sanhita 2023 and Bharatiya Saksha Adhiniyam. As we know, these all three new enactments have replaced our Indian Evidence and CRPC and Indian Evidence IPC sections, IPC acts. So this is for these three criminal laws will provide enhanced protection of the poor, marginalized, vulnerable, while also cracking down on organized crime, terrorism, and other offenses. So if you see the comparison between the existing new old law and the new enactments, I would like to put into the 5 basic points. That is one law and philosophy. If you see this comparison, the old one will be like more punitive and retributes justice, whereas the new philosophy is provided retrospective justice focused on rehabilitation and victim centering. Because due to the short of time, I will not explain what is the meanings of these words. I think we can understand by putting here, sir. And the ideology of the distinguish between these two enactments, when we see, they developed by Britishers and British oversight and ideology, whereas a new criminal law built for the modern India with a focus on very dynamic legal scope. Sentencing, when you compare with these two acts, these two system laws, where there is a fixed punishment and penalties specified various kinds of crimes. In case of new criminal laws, there is a provision for fixed punishment as well as the restorative justice provisions like imposition of community service or rehabilitation. So the word community service is provided now. And when you see the admissibility of evidence, in the old enactments, the admissibilities is not is a limited admissibility, whereas now the scope of admissibility is well defined in the definition as well as there is various provisions are provided in the new criminal laws. The last one, trial procedures, all the old procedures were tiring, cumbersome and lengthy procedures which delays the justice delivery system. Now whereas in the new criminal laws aimed at expediting the criminal process by implementing time limit and leverage technology to enhance efficiency. Actually, every sentence has been, I brought in a PPT slide wise, but due to the constraint of time now, I'll be going fast for the next actual subject. Now, I'll just explain briefly what is the new enactment replaced system. There is one first I'll take, Bharatiya Nyaya Sanhita, which is replaced by our IPC. The key changes including reduced sections from 511 to 358 in BNS, added 2 new offences, compulsorily minimum punishment prescribed for certain offences, community service for 6 petty offences. Earlier it was not there. In certain offences, fine has been increased. In certain offences, quantum of punishment is enhanced. Some silent features, if you see, consolidates the offence against women and children in a single chapter. Section 69, strict punishment for sexual intercourse on false promise. Section 2 of 70, death penalty has a punishment for gang rape. In same way, if we see Bharatiya Nagarika Suraksha Sanhit 2023, the key changes including increased sections from 484 to 531 in BNSS, very few compared to the earlier act. Replaced 177 section, added 9 new sections, repealed 14 sections, enhances use of technology in investigation, increase fine by magistrate, streamlines FIR process and victims protection. As you know, where E-FIR is being given, 0 FIRs is given, that is. Likewise, section 173, 0 FIR and E-FIR provisions are introduced. And section 176, 1, law permits audio video recording of victim statement. This is a new provisions. So next law, Bharatiya Sakshya Adhiniyam, it replaces Evidence Act. It increased sections from 167 to 170 in BSA, hardly 3 sections. Changed 24 sections, added new sections, repealed 6 sections, recognizes electronic and digital records as a primary evidence, provides framework for digital evidence authenticity. This is the main subject for us now. Section 2, the definitions, it has been given what is a document. Earlier, the documents is like, what we make it in a paper, we can say document. Now, audio, video, or electronic, digital is also been defined, and provisions are given to make admissibility. That is the most important topic now I'll be talking, sir. Section 62 and 63, admissibility of electronic records accepted in the court. So, this is our main subject. Before going to the new, this actual section, this enactment, this new criminal laws are effective from July 2024. And just to brief, so as we aware that these new criminal law, whatever it has been implementing and effective from July 24, all the investigations, search and seizures carried before that will be continued in the same old IPC, CRPC, even in the court of law. That I'm making clear with best of my knowledge. If anything, anybody can also correct me. So not only in the old, whatever we did previous to July 2024, when you go to the court, filing a complaint, our complaint is on CRPC 200. So that is changed to now to 223 BNSS. But still you need to file under if the offense has been taken prior to this period and investigation is carried, you have to file under section 200 CRPC. And all trials will be effective or undertakes place only with the old criminal law. So I hope this is clear. So now this is the second part. I would like to touch our main subject. What is the now new criminal law provisions has provided for us. So before going to this, I would like to know, because we are all enforcement officers, basically drug inspectors, why this particular section, mainly I can say, why I have taken up for you, and why today's our organizers has asked me to do this particular chapter. Can anyone say, instead of talking about our search and seizures are mainly under section 22 of Drugs and Cosmetics Act, the title is Power of Inspector. So when we have been specifically given the powers under section 22, then why should we read and why should we apply? So can anyone tell why this we need to read and apply? Where it is? Yes, sir. Yeah, just backside. Anybody? Can anyone tell why we have to read, whether we have to apply this or not required? Whether our act, our special act, drugs and cosmetics, has specified anywhere? Can anyone say? Okay. Yeah, in which section, which provision, can anyone say, sir? Because all we are very expert. Okay. So when we see section 22 of Drugs and Cosmetics Act, 2 of 22 clearly says that we need to follow the provisions of Code of Criminal Provisions. That is mainly we can say section 94 of CRPC as well as sometimes maybe CRPC 100. These two sections, because our act is a special act, wherever the special act specifies or it is a silent for the investigation, we need to follow the other criminal laws. So that is what today's topic is. So before we just know going for what is the new criminal law mandate has and specific to the BNSS, there is a 6 sections which makes compulsory videography, a record of audio video record. So I just put on my slide, we can see what are these sections. So BNSS section 176 proceeds for investigation makes mandatory for videography recording scene of crime. That is nothing but our part of investigation or where we search and seize, place, premises, we call as a premises, a person. These are 2 terms we have got. And this is a mandatory. BNSS section 105 recording of search and seizure through audio video recording. This is the most important and new section has been introduced in BNSS. So it is a must. If you see our section 2 of 22 of Drugs and Cosmetics Act, it also applies. Therefore, carefully observe this. This particular section gives 5 parameters. That is, when you search, it has to be audio video record. When you take in the possession of any drugs or article, whichever way you do it as in today, so that has to be audio videograph. And the third one, whatever you will list in during your search and seizure, you need to be audio videograph. And the fourth one is that most important, the signing of the pancha witnesses, that has to be audio video recorded. The final and 5th point and that particular section, I have divided my to conveniently telling to you all, it is not point wise, is not their section. The 5th is as soon as we complete this process, search and seizure, we need to inform to magistrate, judicial magistrate, which already we have been doing it under section 20, under section 6 of 23. So I hope that provision will apply here. If I'm not wrong, if I'm not correct, somebody can correct me. So same provision, again CRPC has given new provision for policies, but I hope since we have our special act has given a specific provision for intimating to the magistrate, we can follow the same provisions. So next when it comes to the section 176, as I already told, recording of statement of police, that is optional, because when that is one, that is before that, sorry, BNSS section 173 is information on cognizable cases. This is another most important. I am not going to elaborate it, but since we have not implemented, and is the most important, why I am telling when you see our Union in case of Union India versus Ashok Kumar Sharma and others, in UP case, judgment given by the Supreme Court in the month of August 2020, whereas it is clearly mentioned that of section under section 22 of Drugs and Cosmetics, subclass 1 of D, is that the inspector is empowered, is only empowered to arrest any person under this act, not by the police under chapter 4. So the effective or implementation I am not going to discuss because everyone know where it is the status of that case and implementation. So why I am putting this point here, this is a cognizable offense. So when it comes to that, we need to be followed. In the case of DK Balu case of Supreme Court judgment pertaining to the Calcutta, it has given clear guidelines how it be arrest, such and other things has been given there also. So now I'm not going to touch that because my today's topic is search and seizure. But everyone has to remember that when Supreme Court judgment become a law of our land. So that is the reason I'm emphasizing that point. Then in the case of BNS section 176, that is a procedure for investigation, recording of statement. BNSS section 180, examination of witness by police. This also will comes when you start implementing the Supreme Court case of the Ashok Kumar Sharma case. This all for us it has to be adaptable. We need to adapt. Then the final section, BNSS section 497, is order of custody and disposal of property pending in certain cases. This is a very small section we generally follow whenever we see a huge quantity of drugs due to unlicensed and various reasons. At that time, sometimes the quality is in good quality of the drug. The court sometimes releases, and those times maybe this section also useful, sir. And further, I will explain how the recording of search and seizure in other coming slides. So this is another section which we need to be follow for the search and seizure. This is earlier called Indian Evidence Act. Now it is called BNS. So when you see this BSA Act, so I have put what are the changes. These are mainly, I can say, which we all aware. So which we know I am not touching those matters with this given time. I can only say now section 105 has been introduced under BNSS. So that correspondingly we need to be certify the devices, whatever we use for the search and seizure for audio video recording, that has been clearly given under these sections 63, 64, we have to be certified, and this electronic and digital records has been admissible, and at what is been admissible 61 is given, evidence has to be recorded, 62 gives more clarity in how it should be done, 63 is a certificate, and the 64 section says that how the secondary evidences when in the case of dispute, how it should go, and then 65 is again this given if the dispute in the handwriting and other those provisions has been given. So once these are very now presently corroborating to the, I'm just corroborating to the section 105 of BNSS. So I have got what is the kind of certificate format also I'm having, I will share to the organizers, they can share later, sir. So now I would like to have the best of my knowledge, and also there is based on lot of Supreme Court judgments, the lot of our central agents including CBI and other agency, they have got an SOP, how the search and seizure should be carried out under the under audio video graph. So and based on that I have taken some points, and that based on that I have drawn the flow. This is only flow because this has to be, as per these SOPs, every state has to need to be form a guidelines how this audio video has to be done, because an individual cannot be done this particular job. So it has to be in a collective way, as a teamwork need to be there, and lot of not only technical our expertising of our officers, it needs an IT professional job also is involved. Thereby, say when we see audio video means generally today we came from morning to evening, we have got lot of loaded message, WhatsApp photos, videos. By evening, most of them we may delete or we may edit, or somebody put it in a beautiful way, their own way of background of music, and so many things. They will put with a frame, so all those cannot be admissible in the court of law. Make it clear, I make it clear, this is very simple. Today's function, we have lot of videos and photos. So we definitely, as a human tendency, we change, we put a color. I mean, I'm not like a fair to others. I definitely have a good color, likewise. So generally it goes, but that is not possible. Even when we did under our executive sir in year 2000 itself, we did one unlicensed premises. That time complete we have taken a videograph and photos. At that time, at the most, we had an original film. That was the concept has been told us. But that was not even taken by the court also. Court was relying on the original document only, because there is no definitions, or there is no compulsion in the definitions anywhere it is given. Now it is not the case. Compulsorily, apart from your document, the value of the document is also equal to the digital records. So it is a must, both simultaneously it will go. One side may be documents, what importance is there, and the same way the video, audio recording have got the impact. So now the world-wise, the most acceptable evidence is electrically digital evidence. It will have a less manipulations, more transparency, accountability. It make us to more speedy trials and victim centric. It is victim favorable because, and also it also allows this now, even by this amendment, the witness also no need to come to the court, trial court. So all this has been amended and given effectiveness for the admissibility. The only what we have to do, because we are a part of enforcement, we need to know streamline. So there's nothing to worry about this, much of this. It is only just we have to streamline how it should be effectively be carried out. I'm just briefing out. It can be not necessarily go in the same pattern you need to go. And you can also have a state-wise SOPs. That's the most important. SOP for photograph and videograph, first respondent. This generally it is an IO. Who is IO who carry out the investigation. He will be the first responder and reaches the scene of crime or place of accused, witness or place, things to be searched. So here when it these points, no, we need to be preparedness. So preparedness, what we do as on today, apart from that, we need to have a good device. When you say device, the list of devices is there depending upon the crime, the length of video, the number of how many equipment you required, whether it is how many charges, all this will come count, because I cannot, it's a short period, I cannot explain everything. So the preparedness, what you required, whether you want only mobile, it says preferably mobile only, but mobile, with a mobile, we cannot do it in a one day, half day. If it is a small chemist shop, 1 hour, half an hour, you can finish up and come back. If it's an industry, no, you cannot. It need to be 1 day, maybe 2 days. And with one equipment, we cannot go, because industry it is a cubicle. It is a warehouse one side, and chemical one, lab is another floor, and manufacturing another floor. All collectively you have to put. The search and seizure is not in a one place. As I explained, section 105 has given 5 major points. All has to be covered. That is what we can have in our recorders, CCTV records, and it will pass to the, there could be 5 CCTVs. It will come to the main one memory place or computer connected to the hard disk. So all these are connected. So this has to be taken care of this, sir. Once your device is ready, it says device. So earlier is reaching the place. One is added is a device now. So when you see the device, that is called videography procedure during the search and seizure. The most and foremost important, now earlier what we know, just for when we go for sometimes very casual talking, there cannot be no loose talk, the movement should be restricted. The videography, the focus of videography, how you want, there is a different methods are given. File line method, there is so many methods as you have to choose what type of search is going to be taking place, whether it is in one premises, multiple places. Depending upon that way, you have to choose your videography. So once you choose whether video, mobile device or audio video record. See, mobile with a single person, it is very difficult with my experience taking in search and seizure. So once you choose a mobile device, activate app or tool to record, because the two title is given, the government of India under these provisions has been going to develop a e-Saksha. So time is given 2029, the year up to still that time, an app will become. So once the app comes, it is developed by the NIC. So that one, all the search and seizures, you can immediately load it, it will be online. The once moment you online, it will go to the even respective judicial court, and filing also online. All the transmission of your data will go online. That become easy also. Maybe that may take some more years to come. But as in today, you need to record it. So once you record it, perform the photography, videography. So how you want it to be done. So once this is a very difficult task, because one side you have to document, another side you have to record it. All those things should be taken very carefully. See, we have to see that the admissibility of the electronic device and with a certificate under section 63 of BSA, and that has to be authenticity and data integrity should be given through harsh value for the source of the data. So these are most important. Only I'm very plain way I'm explaining. We need to be taken care when you're doing videograph. So once you connect, then after the incident, so that is for connected the capturing of essence of place, process of preparing the list of seized items, signing of witness. As I said, no, 3 as mentioned, there are 2 more points also there. So those That is the main job. So this is need to be now new, as per the new provisions, you have to adapt. So once you did that, then you have to connect to your computer or destination where you want to do, record or archive. So this left side is a mobile. When you go to the audio video recorder, it insert a fresh, because fresh read only. So there it is a flash drives or pen drive or whichever data card, all those will come. You have to choose. If it is a smaller kind of such and seizure, you may use mobile. But Act clearly mentioned preferably with the mobile. So those are the bigger things, go for videograph, audio video. Once that is over, then it has to go to the mirror image of the file generate for the producing in code. So next slide is pertain to technology procedure for storage and transportation. First one is the preparedness. Second was videograph, how you have to do it, videography. Now, how do you transfer? This is the most important. So this, when you come now mobile, if you are recorded in the mobile, you need to develop hashing done. So I'm not going to explain how the hashing is done. So most of them knows. If not, does not know, you can find in your YouTubes. It is explained. So hashing as is a compulsory. It is a compulsory. Otherwise, it will be duplicating. The audio videos become duplicating your process. So once hashing is done, you need to obtain the number. It gives a character, line of character. So and documented. So hashing can be done even if you're continuous search. Today you are completed. Tomorrow, if you're taken up, what is been done today's capturing of the audio video, it will give one particular character. Then tomorrow you can continue. It may be same search and seizure, but it will be different character of hash value be given. So this is a more, as per guidelines of central agency, this is the most important. Our act does not say, either criminal law or drugs and cosmetic acts does not say how it should be done. It only says, as I explained, section 105. This is additionally for uniformity, I'm just telling this. Once hash done, hash obtained documented, then chain of custody will go. Before this, no hash is done. Once data is developed, put into the hard disk, that will become a major negative record. So without opening, you do it. From there, major negative record, you can again transfer into the pen drive without opening. Then also you can do hashing. Still that time it is intact. Your data is intact. So after that, that will be the primary evidence. Now these two things I would like to explain. There is now also two evidences, two primary evidence and secondary evidence. As we are aware of this, what is primary evidence documents and secondary evidence document, like Xerox copy, other things. Similar way, these provisions have got both kind of evidence. Once hashing is done, it is a primary evidence. And why am this telling? No. So most of particularly we are in a transferable job. So once you finish your particular period of 2 years, 1 year, you might have carried 100 of such and seizures. So all these data, individual pen drives, individual data, memory card, it becomes huge quantity, huge number. You need to hand over to the producer. So he has to carry on and he has to go to the court. So it's all to be, we should be, that cannot be allowed to any manipulation, need to be done hash. So that is the most important. Still complete disposable of case, this has to be protected. So once the hash is done, then chain of custody, certificate has to be done under section 63(4) PSA. This is the most of the important. Our department of Raghuram and Dayanand who are here, Senganna, we have done it also already in most of online cases. So I have got how the certificate is be done. So it's not necessarily that if you are using a mobile, not necessarily the owner has to be done, and preferably it has to be done by the mobile or any device issued by the department. That is the most important, which is otherwise is very difficult to show maybe. And the certificate as far as the certificate is concerned, not necessarily the owner has to certify. Who has handled the scene, he can certify it. And there is a certificate A, B is given if you are expert. If you are taken any your expert, maybe forensic expert or maybe IT expert, he can also certify. In that, before the certification has to be done, whether you do it in mobile or you do it in a audio video. So here another most important is there, the process of audio video is from the beginning to end. It is not in a part. It has to be complete of your search and seizure. Just imagine, telling is easy, conducting and doing is a very big job, I know, because I have done several such as seizures, and it should be complete. And then you need to know before concluding your Panchanama, you need to write your ash value in your part of Panchanama. So unless you did it that, it will be very difficulty admissibility in the court of law. So you must know before start your seizure how the ash value has to be generated. So you must learn it. So next slide. So transfer the mirror image chain of technology. So there is a 3 slides, the 4th slide part of the audio video graph. So once mirror image is created, so ash value is done, then you are copying. That is also treated as a primary evidence. This has to be, as I said, there is you need to be intimated as soon as the seizure and such taken place, act as given, section 6 of 23. So immediately we have to inform. And later the complete of investigation has to be carried out, and then filing of also charges along with the, it may be by the time we do it, it will be e-filing, or that, as I said, that app-based e-saksha is developing by central government or NIC. It is there in the provisions. It is time also specified at what period it has to be done. So automatically it go. That is called chain technology, image chain technology. We need to transferring. This is the 4th slide, says how do you transfer these electronic digital evidence. So the 4th slide. So with this, I am completing the section 105 of search and seizure, including a brief SOPs, how it should be carried out. So now the technology, the new criminal laws has given a very much provision, witness protection scheme basis. As I said, now onwards, witness no need to come, not necessarily to come to the court, trial courts not necessarily. For the central government, and this provision is given, every state has to notify the witness center, but not the police station. Other than police station has to be notified, such that the trials will be fair, it will be speed up, and then it will be also victim-oriented judgment favorably. And now courts, that is a major provision has been incorporated in the new criminal law, that is safeguarding the justice witness protection scheme. So the last and final slide, enhancing digital forensic capabilities by emphasizing on these areas. As enforcement, as well as generally we say, everyone talk about the work, how to do, unless the facilities being provided, how we can do. I have told all these 4 slides, the SOPs and section 105, but how to do, and the question will rise. That also I would like to cover. So all state governments need to be maybe provide this. This will involve strengthening infrastructural facilities across state and union territories, providing necessary gadgets for collecting, transmitting, storing electronic device, and training manpower in this regard. This is one of the most crucial. Looks like it is in 4 lines in a language given in English. It is not that way. Every word has got weightage. Guidelines should be developed to protect equipment quality, secure storage, protect electronic device, maintain data integrity. Very, very difficulty. We work as 6 months, we move one place to another place. We just handing over physical file itself is a great difficulty. And see, you need to have all this data has to be stored and need to be handed over to the next level, need to be carried on to the court. All this has to be taken in mind when you're doing all this work. States and union territories need to ensure the electronic device is handled securely and protected from loss. Equally important, states can mandate training and certificate of digital forensic experts to qualify for evidence collection analysis. The provisions are given. We need to certify our officers how it should be. Tomorrow the court will ask you, how do you done? Where you done? Ask you are done. Value who has done? Then he is there in the scene. He is not there in the scene. Then all this will come. So you need to train them, certify them. So that will be only the admissibility. Then the states can, the central government could authorize joint certificate by these authorities for digital forensic expert, budgeting and costing, dedicated vehicle, room, facilities, all this has to be provided. These are the things which I have thought of, explain to you. Thank you. This is only my sharing of the sections. Any doubts, with best of my knowledge, I can clarify.
Thank you very much, Mr. Ramesh. I'm just trying to understand, is there is any drug inspector who has made minimum at least one seizure? Please raise your hand. Those who have made minimum one seizure. Minimum one seizure. There are many drug inspectors not yet done a single seizure. So the most of the drug inspectors are regularly doing the search and the seizures. Now, as you explain the new IPC, CRPC and the Evidence Act, does it necessary, is it mandatory for every search and seizure to make a videography?
Yes, sir. It is a mandatory, sir. New section, as per new section 105 of BNSS, mandatory, sir. Because
it's a mandatory for the every search and seizure to make a videography. How many states and how many inspectors are observing this provision? Very few. Okay. Now, my another question is, can you make the videography by our own mobile?
yes, sir. The act is clearly mentioned that now preferably with a mobile phone, mobile. It is clearly mentioned, but as an enforcement officers, we know the difficulties. That is why I put my last slide. Every state has to take up this issue, sir. Without this, no, it will be very difficulty for our officers, train up and all those, it has to be, SOPs has to be framed, those things.
It should be personal mobile or it should be mobile given by the office?
The act is silent. If you refer central agency like CBI and other, they clearly mention it should be preferably in a department provide equipments.
Okay. And how, suppose my inspector goes for the raid and does the videography and audiography also, and then how to get the certification for the as well?
Certificate is very easy, sir. There is a format I am also sharing, and it is not necessarily that as per my knowledge there is no specific format, but generally it is been established by national agencies we have got. It is very simple, sir. Certifying that what are the device you have used, model, everything, who is the owner, who is handled, and when your calibrations, those things, and ash value also should come.
Who are the such agencies?
CBI agency, they are using that certificates. No, sir. I'm telling there is a format is available. If you want to have a draft like format. That is right, sir. My last slide is very clear that all state drug control department has to provide guidelines. Section for section 105, we need to format a guidelines how it should be done. I have given, sir, this is what it has been recommended.
See, this is really the transforming changes are the mandatory provisions incorporated into the new Evidence Act.
Yeah,
Okay.
BNSS, sir.
Yeah.
Bharatiya Nagarika, sir.
It's a really transforming provisions. See, we are doing the search and seizures, we are doing the Panchanama, but up till now, we are not making the audiography and the videography. Now you say, as the new new enactment is already come and it's already applicable from the July, and for the search and seizure we need to make a videography and audiography. Means tomorrow if my inspectors or our inspector doesn't make the videography and audiography, then it will be the non-compliance of that provisions?
Definitely, sir, it is non-compliance. That is what I started telling when I start my topic. I told you section 22 of Drugs and Cosmetics Act clearly mentioned subsection 2. We need to follow the provisions of criminal code procedures.
So it should be certified by an agency. Which agency it is not mentioned?
No, sir. No agency is not required, sir. Who has performed, who has used this equipment device, only he himself, sir. He can be owner, he can be the second who is handled at that incident. Not necessarily owner also. Anybody can certify.
So one of our inspector has seized
Yes, sir.
using this provision.
Yes, sir.
But magistrate is not accepting.
Because
some agency has to be certified. That's what in Krishnagiri we had a problem.
Okay. Sir,
Sir.
as you said, sir, rightly said, sir, with your experience, I am just telling there is a clear provision. Certificate can be done by an expert or the man who has used the device or this site of scene, search and seizure, that is acceptable, and hash value has to be done. These two things required, sir. Because the Act is says you must ensure the admissibility of electronic data by certifying under new as per IP Evidence Act,
But electronic data means any mode.
any modes, either mobile or video, sir.
Thank
Yes,
you.
please. I am Assistant Drug Control, Karnataka, Haveri district, myself Sanganda. As sir is explaining about this seizure and search by electronic mode, by own camera, there is in fact in the police system, IPC in the seize and searcher, they produce all photographs and all those things. There is a digital form presenting, the form 63 something is there, they are presenting before the court. That means whatever you take photos, that is printed in some of the photo studio and all, he will certify that it is originally taken photos and printed given by me. Even a statement also is recorded against for the same thing. Recently after amendment, one of our officer has took seizure and search, went to the court for permission for the judicial custody of this thing. He immediately judge insisted, where is your electronic recorded details? He did not give permission for retention. So the situation, judges are aware of the these things, and all laws in under this thing, they expect this type of mandatory provisions. So you have to get prepared. It is mandatory. It is mandatory. There is no this thing, and ultimately he gave one suggestion. This time I'll allow it. Next time onwards you don't do that. You come with the all procedure as in BNNS it is described. So please think this in the procedure as sir has stated. So all state SOP procedure has to be adopted. Thank
Sir.
you. Thank you.
This certificate is, 1 minute, so the certificate clearly mentioned, see section 63(4)(c). You just certify, you just say is a schedule part of certificate, mention the provision of section 63(4)(c), certificate, and then I, so and so, like that. It's very simple, sir, any format.
Yes.
It's,
After such a informative lecture, and thanks to Mr. Ramesh, and
Thank you,
we can take this that the every state has to prepare and has to prepare the SOP for the videography and audiography while making the search and seizures. What will be the modality, what will be the certifying agency, and how the videography will be taken. That has to be discussed at their state level, but it's a mandatory provisions, and the magistrate will
I
definitely
suggest,
ask.
excuse me, Gahane sab, I suggest because it is involve all the states and CDSU also, why can't a committee be formed and form the modalities? Because it is not 1 day's job and 2 day job. Every alternate day somewhere else seizure will be going to happen. What he has told is, it may be the provisions of BNS, or
BNSS.
Evidence Acts, BNSS, sir,
BNSS, sir.
BNSS. So those provisions applicability with the consultation of some advocate or whatever it is there. Though we are experts in this one, I think it is better in the interest of for all the states and this one, uniformity should be there. Otherwise it will be very, and again
Then-
government budget is required.
But sir,
Government budget is
yes,
the most important. How can you say your mobile, you can tamper with your mobile? How can it be accepted? It is very, and if you bring somebody outsider, he is your friend, they may say, how can you do it? It is a practical difficulties,
Sir,
I feel.
I totally agree with your concern and your suggestion, but if you wait for the directives from the CDSO, many years will. So some state has to start, and if the SOPs and the practices adopted by that particular state, we find it ideal, then it can be applicable to the other states also.
Yes, sir.
Sir, do we need to have these geographical coordinates also to be recorded, longitude, latitude, etc. of the location of the place? How you
yes,
can,
sir. See,
so
the
that it can be correlated there in the,
the
as a proof.
section, the provision of section, as I read now, only 5 points, it is a very, that is the points. And when you see some SOPCs, it is mentioned that also, sir.
Okay.
Yeah,
It has
in,
to be recorded
Yeah,
there.
home department, central government, home department, SOP, if you see, it is written that also, that point also covers.
Okay, thank you.
Thank you, sir.
Sir, can you please explain about the hash value, sir?
Yeah.
What
As
is
I
hash
said,
value
sir,
and what is its
see,
significance?
I have explained what is the importance of the hash value, but I am not an expert to know. You find out in YouTube, it is given, sir. When you do it, no, once your data you transfer to a particular software, it will give. It's a character it gives, including photos also it gives.
Yeah, thank you, sir. Just one brief question. I mean, this photography and videography, is it applicable to all cases or only cases pertaining to which punishment is more than 7 or years?
No, sir. It does not say. It only says in case of police, it is a cognizable cases, forensic expert is required. Other than that, it does not, it is silent. It is all cases in this. We need, if it's a punishment is more than 3 years, forensic expert is required, rule says.
We need to confirm this. I think the punishment clause is there.
Okay.
Above that, only recording is required. We will confirm it.
Yeah, thank you, sir.
Sir, my question is the whole process is to be video audiographed or only starting, middle and...
No, sir, it says the guideline, the act is, as I read, no, act does not say, if you see the reference of some standard SOPs, it says admissibility means no. If you take part and parcel or some here and there, it definitely gives a chances of, it does not a transparency. It may be manipulation, every chances are. It says clearly from the point beginning of your search at the last point, it says.
Sir, one more question, please. Suppose I am entering some premises which is unlicensed.
Okay, sir.
Before entry, I don't know the shop is having a license or not.
Yes, sir.
I just entered and inquired about the license. The person saying that he is not having license. From what point I should videograph start the audiography and videography?
So as you know, sir, you are talking, it says search and seizure.
Yeah.
So search is a part of whether when the search, all search will not end up with violations.
Okay.
Maybe seizure. So search also part of it, sir.
Okay, sir. Thank you.
एक सवाल मैं पूछ सकता हूँ?
Yes.
ये आप जो बता रहे थे कि स्टार्टिंग एंड द एंड.
Yes, sir.
तो दो चीज़ें मेरे दिमाग में आ रही हैं कि मैं वीडियोग्राफी कर रहा हूँ स्टार्टिंग और नेटवर्क वहाँ पर प्रॉब्लम है या कुछ बैटरी चार्जिंग नहीं है या डिवाइस में कुछ डिस्टरबेंस है, फिर क्या हुआ?
That is a preparedness, sir.
अच्छा.
Preparedness, you can explain your own ways.
नहीं, हम कितना भी प्रिपेयर
That's
रहेंगे
what,
तभी.
nah, preparedness means you have to back up. Battery should have everything. So preparedness.
ठीक है.
If I tell it can be 1 hour, 2 hours, it will be, sir. It's a preparedness.
Sir, during search and seizures, when I am doing the activity, suppose
Yes.
I am writing the seizure list, a list of medicines. So during that time, total video I have to done from starting to end.
Yes.
So how can I do that? There must be second person must be there. If they present, then
Yeah, that's what, sir, I written here. See, strengthening infrastructure facilities, this has to be done now. See, as and today the act has came, even there is a provision, the central agency also developing an app. They have taken some time. Now it is a challenge for you. Yes. So as we see, as and today, the search and seizure may not happen a single person. Most of the cases,
Yes,
a
yes.
rare case happens with one person. So you know, that is a preparedness. You, whether it is a bigger, you have to accompany somebody else.
if second person do the video that time, then it will be allowable or not?
Yes, sir.
Okay. Yes.
No, I am a retired additional risk controller, Karnataka. What I suggest is, sir, start from the portion when you take a witnesses. From that portion, if you start your videography, till end, it will be a better one. Rather than, because we don't know. We enter shop, we find some offenses, we call witnesses. From that point also you can start it. We are not no when we will be searching or when we will be searching. Sometimes we go for inspection, sometimes we go for search. So it is better when we obtain witnesses there. If you start it, it will be better. Okay.
Sir, one more question, please.
Say, we'll conclude here.
Sir, one last question, please. When I am audiography, or I am doing the videography, and many persons are coming inside the shop and going outside the shop. In between, my search and seizure. So every person who is entering in the premises, is it compulsory that he should be mentioned as a witness in my list?
Who is coming?
Means I am doing search and seizure.
Yeah.
Some persons are means it is a local shop in the market. Many
Uh,
persons come
I understand, sir. It says no first slide, preparedness, safety, and the interference, including press and media. All this has to be taken care. And there is a methods. There are 6 methods are there how to search and seize videography. If, depending upon the location premises, there is a process is there.
So we have to avoid the
Yeah, you definitely have to
interference
avoid.
we have to avoid.
Everything will be recorded. The magistrate will see. No, so admissibility will come down. Doubt.
Thank you.
Thank you very much.
Thank you.
One more.
एक सवाल
With the permission of Mr. Ramesh,
Sir,
if Ramesh don't
Ramesh
have
sir,
any
Ramesh sir.
objection, we'll share this.
Yes, sir. I will give
Ramesh
this
sir.
We
along
will share this presentation to all of you.
and copy of certificate draft also I'll give.
Okay, and every state has to think over this provision, and accordingly we'll make the standard SOP for the states.
सर मैं ये बोल रहा था कि गूगल में सर्च किया अभी सेक्शन 176(3 of BNSS introduces a mandate for collection of forensic evidence in all offences punishable by 7 years or more.
Correct.
Right?
Yeah.
And the videography of the process on a mobile phone or any other electronic device.
Yeah,
So that's what I'm saying. If the punishment is 7 years more, in that case only videography is to be done.
Sir, you
Not
need,
in all cases.
I understand, Ravi sir. It is a section 105 as the main act for us. So we don't have any forensic expert for our authorities. So as per mine, I'm just, as I said, it is an understanding. So we need to follow section CRP, section 22 to 2 subclass, subpara. So their criminal procedure code has to be conducted. 105 has been incorporated.
Okay.
That is for police. 176 proceed investigation by police officer.
Wow.
You
Okay.
see, the heading itself is given investigation by police officer.
Okay, we'll discuss more
Yeah,
on this.
definitely,
we'll
sir.
need
It is only
more detailed
sharing
discussion.
knowledge,
Yeah.
exchanging.
Okay, so it was a wonderful explanatory session by P. Ramesh sir. Now it's time to felicitate and present memento. For that, I would like to request V.T. Paunekar sir to please be on stage. He's the Joint Commissioner, FDA MS. Can we have a big round of applause? So we are